and it's only gotten more interesting over time. And music copyright is one of the places where it's gotten more interesting. We have a great panel, and we're going to hear first from Regan Smith, who's the General Counsel and Associate Register of Copyrights with the U.S. Copyright Office. She's going to be talking with us about some issues that the office has been addressing in this space, particularly about registration and deposit copies, like what is the musical work from the standpoint of how the office understands it, about what kinds of things are copyright protectable in music from the standpoint of the office, because they filed a brief in the Led Zeppelin case that I think was very interesting. And we'll hear a little bit about de minimis and about that tricky question about what's the difference between the sound recording and the musical work, and what things that are performative are within the scope of which copyright, and that's actually something that is bedeviling the courts. After that, we will hear from Ed Lee, who is a professor at Chicago-Kent Law School and the head of its Chicago-Kent program on intellectual property law. He's been writing lately about whether fair use should be given more attention in music copyright cases. Fair use defenses are actually pretty uncommon, or have been pretty uncommon, but maybe they should be more so. After that, Lateef Mtima will be our next contributor. He's from Howard University Law School and the Institute for Intellectual Property and Social Justice. And he's going to talk to us about what's ideas in works and who are these litigations really impacting, what communities are really worried about that. And finally, Kevin Erickson, who's with the Future of Music Coalition, is going to talk about what all these debates that these lawyers are having, what kind of impact is that having on the way that musicians are thinking about what they can and can't do, and also who is being really impacted by some of these lawsuits. And so I think it's going to be a pretty wide-ranging conversation. So Regan, would you please get us started?
Thank you. Let's see. Okay. Thank you, Professor Samuelson, and thank you for having me here today. As you mentioned, I would like to take my time to step back before we get to infringement and talk about a little of the legal and policy frameworks from the perspective of copyrightability and the formalities, requirements to register your copyright with the Copyright Office and how that might affect infringement analysis that we get to. So I have some basic slides to start with. The first one is just originality. To have a copyright, let's see if this works. Yes, okay. Obviously, you need to have an original creation. There needs to be a modicum of creative expression, and the Copyright Office evaluates the originality requirement daily by administering the registration system. Section 202.1 of our regulations codifies the office's approach that short phrases are not copyrightable, ideas are not copyrightable, works of common property are not copyrightable. There's a list of those things that are taken from the Supreme Court's Feist opinion, from Title 17, 102B, and other circuit cases. It's built up over many decades, and the office's views are generally well received and used in district courts, and have received deference many times in private litigation or administrative challenges for this. As far as music specifically, we have a practice guide called the Compendium that talks about how the office thinks about registering musical works and sound recordings. So in terms of applying the common material standard to musical works, it says some examples of common property include diatonic or chromatic scales, arpeggios, or chord symbols based on standard chord progression. So those are things the Copyright Office would not register, nor would we register a short phrase consisting of only a few musical notes. For sound recordings, similarly, the office says the same thing. Short sound recordings may lack a sufficient amount of authorship to be copyrightable, just as words and short textual phrases are not copyrightable. And I don't think we've been pressed very often to look at what that line is. We do have one case from the Copyright Office Review Board, which is sort of like the last stop in administrative adjudication over the Intel spiral. It goes dun, 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 dun. And the Copyright Office looked at the sample, what came in, because we look at what is sent into the Copyright Office, and that's what we evaluate, and determined that the sound recording aspect of it was copyrightable, but not the musical work based on the deposit material. So we kind of looked at that, said there are some performative elements on the sound recording side. So as Professor Garcia explained really well, there's a difference between musical works and sound recordings in copyright law, and that distinction drives different rights, it drives different statutory licensing schemes, and so it matters. But an interesting thing from the office's perspective is that what is registered is often the same thing. It will come in under the same MP3 or other deposit, because under Section 408, a phonorecord, such as a recording of a musical work, can be now submitted as a deposit, and that is a very common way, if you have the requisite, ownership of both sides of it, that you may register the musical work and the sound recording at the same time. So when sending something to the Copyright Office, generally, Section 408 says that you need to provide the Copyright Office with a complete copy of what you are seeking to register the claim in, or a phonorecord. And there's some administrative flexibility to alleviate that requirement by accepting identifying material, but that is not currently exercised in anything involving sound recordings or musical works. And why is that? Why does it say phonorecord? Why is that word there? That comes out of the law because this wasn't always the case. So sound recordings were not federally copyrightable until 1972. And under the 1909 Act, the office's regulations said a phonograph record or other sound recording is not considered a copy of the composition's recording on it. And the office did not accept recordings to register the musical work side of it. And that came from kind of a long precedent in musical work copyright law, starting from the Whitesmith-Apollo case in 1908. The Supreme Court said to be a copy, there must be a written or printed record of it in intelligible notation. In the 1909 Act, which updated the copyright law then, the legislative history says that these piano rolls and phonorecords, we cannot think that they are copies within the meaning of the Copyright Act, and so you have this concept of a phonorecord. Also under that act, under the 1909 Act, copyright was secured by publication of the work together with a notice of copyright. Publication did not include distribution of a phonorecord when you're talking about the musical work. For unpublished musical works, an author could obtain copyright by registering with the Copyright Office one complete copy of the work, but again, phonorecords were not considered copies, so the office didn't accept them. And the musical works captured in phonorecords were considered unpublished. So we required sheet music or another form of visible notation to register the claims to copyright. Looking at the changes necessary for the 1976 Copyright Act, the 1961 Registrar's Report recognized that this was limiting. And so there's a report saying that transcription into written notation required for deposit is difficult, it's expensive, it's perhaps privileging some forms of expression over other ways musicians are creating songs, and the Copyright Office said maybe this should be changed. And so it was under the 1976 Act. Now, under Section 408, phonorecords can qualify as recordings of deposits, of musical work deposits. So where does that leave us now? In 1978, all unpublished material became protected by copyright. This was a change when copyright subsisted upon fixation, and it becomes, in some extent, a registration issue. So something that was in a recording, not registered through a non-recording deposit with the Copyright Office, now has copyright protection, but may not be registered at the Copyright Office to overcome the requirement to get into courts. So I think there's two considerations for that. First is maybe, since this is the policy panel, going forward, it seems to have improved to be able to send a phonorecord if that is more easier for lots of different musicians. And secondly, you can look at the existing deposit copies. Maybe you're capturing what a musician is thinking is most important of the features. And if not, perhaps the remainder material could be registered to complete the piece, or sort of as a derivative work. By sending in the deposit requirement now, there's sort of nothing stopping sending that in to register the claim. And this is just a quick slide about the We Shall Overcome case, because I think this is a case that illustrates the importance that registration can have in these types of cases. So the one in the middle is the lyrics to the 1948 registration with a copyright that says, "We will overcome, we will overcome, we will overcome someday." It was not renewed. And then there's a 1960 copyright registration, which was at issue in the case. That is, "We shall overcome, we shall overcome." And the court said substituting the word "shall" for "will" is contestantly trivial. It did not, it's not sufficient to create a new derivative work authorship. And that was dispositive, I think, in the court finding that "We Shall Overcome" is in the public domain. But connecting this to infringement considerations, the government did file an amicus brief in Skidmore versus Led Zeppelin. And, you know, if you're wondering, was it fun to go into DOJ and say, "I think there's a significant government interest in Stairway to Heaven"? Yes, that was sort of fun. But where the government interest was in explaining this deposit requirement, what had happened under the 1909 Act, which was the relevant copyright law for the composition torus, and looking at what is coming into the Copyright Office, remember, being the complete copy of the work, as helping influence the infringement considerations. So the government's brief says that the deposit copy in this case should define the scope, and you know, perhaps if there's additional elements of the composition in a recording, that could be registered separately, but it's not before the court. And then looking at copyrightability, the office argues that the copied portion of the composition at issue is subject at most to a thin copyright, and that standard musical elements are not protected. And a thin copyright would be evaluated under a virtually identical consideration. And it talks about some of the examples that the office has in its compendium as far as short musical phrases and chords and arpeggios that typically we would not consider to be copyrightable itself. And I think some of these principles might be helpful in looking at some of the cases that have come through the courts. On the side of lyrics, you see perhaps a tendency a little more for courts to be dismissing these cases. The phrase "walk it, talk it," or the "shake it off" case, although that has been on appeal, were dismissed as not copyrightable. The phrase "party and bullshit" was dismissed as fair use, which I think is sort of interesting, but also the Copyright Office probably wouldn't register that phrase by itself. Versus when you're looking at musical elements, it gets a little bit more complicated, and that may be related to these performative aspects and understanding where the line between what the musical work being registered is versus the sound recording, and the courts sorting, you know, addressing some of that. And then just a last note to think about is whether there's a difference on the de minimis standard. So you have the Sixth Circuit holding that there's no de minimis standard for sampling on the sound recording side. And then you have the Ninth Circuit saying, no, there is. There's nothing special about the protection for sound recordings. It's just a limited protection, but that does not affect evaluation. So that's what I've got, and happy to continue the discussion. Thank you.
I think we wanted to go through this first, but I know she'll be happy to answer many questions. Mm-hmm.
Alleging infringement by another musical work since the inception of the 1976 Act. And basically, in this study I found, by and large, fair use is not typically pursued outside of a handful of cases involving parody fair use. Going back to Campbell versus Acuff Rose, as we all know, one of the Supreme Court. Now, one of the reasons why that fair use might not be pursued is that in the vast majority of cases, as shown in this chart, the defendants have prevailed in music copyright infringement lawsuits. Roughly 90% of the cases. That might be changing more recently. In addition, there are other grounds, as shown in this next chart, on which the defendants have prevailed, mainly on challenging the elements of substantial similarity, whether it is on the access prong or on the prong of misappropriation. So one reason maybe fair use has not been pursued in the past is that defendants have prevailed in the majority of cases on other grounds contesting substantial similarity. But even in the cases in which the defendants have lost, they typically have not pursued a fair use defense, as in the case of blurred lines, even though the defendants admitted to some potential barring of something, whether it's the groove or something else. So the main finding of the first study that I did was that fair use is not typically pursued in music infringement cases outside of a handful of cases involving parodies. So that led me to the next study where I teamed up with a co-author, Dr. Andrew Muschernia, where we ran an experiment to test if fair use would actually matter in music infringement cases. So we conducted an experiment, and here are the basic contours of this experiment. We tested over 500 subjects using Amazon Turk. We created a fact scenario, a very simplistic fact scenario involving two sets of cases. One based on the music in blurred lines, another set of cases based on the music from the Harrison case, My Sweet Lord and He's So Fine. Now, we were not retrying these cases, I should underscore. We were creating a hypothetical case based on the music involving instrumental versions of the respective songs in these cases. And then we ran 4 cases testing substantial similarity, not access, but the actual question of misappropriation, and testing also fair use. And the reason why we chose these 2 sets of cases or music is that we wanted to have music that potentially could be found to be infringing. So we know from the results in these cases they were. But we also wanted to have cases that arguably there was a fair use argument could be made. We classified the blurred lines case as a case of low similarity compared to the case involving George Harrison, My Sweet Lord, because there were fewer note for note either identical notes or similarities in sequence. And that's the reason why we chose the 2 sets of songs. I don't want to go through all the facts of the case, but it's a very simplified version. This is what the subjects would see online on Amazon Turk. They're given the opportunity to listen to the instrumental versions as long as they wish, and then they're given jury instructions. A very simplified version of the substantial similarity instruction. We base this on a composite of jury instructions given in cases, as well as a composite of pattern instructions from various circuits. And this instruction was similar to 2 other experiments involving substantial similarity that were used by other scholars. So we, sort of validating our instruction was within what others had used. The fair use instruction is a little bit more challenging to present because obviously you have to give the 4 fair use factors in Section 107 of the Copyright Act. We also included a quote from the Acuff-Rose case involving transformative use in Factor 1, but otherwise this hews fairly closely to the statute. Okay, what are the findings of this experiment? Well, the first main finding is that fair use does matter. Now, maybe to the copyright students and professors in the room and lawyers as well, this does not seem like an earth-shattering finding. But let me just throw out one possible hypothesis why this is worth proving or validating with this study. Some might say, well, misappropriation and fair use, the fact finder might end up with the same result, basically treating misappropriation as going too far or being unfair, as well as making the determination of fair use as something that's unfair, and in a post hoc rationalization, just doing the analysis under the respective tests. What our findings showed is that that's not what's going on in terms of these music experiments. Okay, so in this chart, you can see that in terms of the findings of no liability, depicted in orange would be the number of findings of no liability finding in favor of fair use, compared to the blue would be no liability by rejecting substantial similarity. So as you can see, the orange bar is greater than the blue bar, meaning that there were more findings of fair use than there were rejections of substantial similarity. So fair use does matter, basically. Relatedly, this is an interesting sort of sub-finding of this first finding, is that people were more confident in finding fair use than in rejecting fair use. So we asked the respondents, how confident on a scale of 1 to 10 are you in making your finding, whether it be substantial similarity or fair use? The only finding that the respondents showed a lower confidence, below 7, was when they rejected fair use, which suggests that if you present a fair use defense, the fact finder or the jurors here would be taking into, I think, consideration their worry about whether, before rejecting fair use, whether they were right. Okay. The second major finding of the experiment was that knowledge matters, and this relates to the gentleman's question before about the jurors' lack of knowledge or expertise in music. We found that people who had knowledge in music, or the law generally, being law students or lawyers, and then the question about musicians, either they studied music or actually were musicians, that actually had a significant effect on the findings. And it had an effect that maybe is surprising. The effect that we can characterize is somewhat of an inverse relationship. People with knowledge of music or the law were more likely to find substantial similarity or infringement, given the test of substantial similarity. By the same token, those people with such knowledge of music or the law were more likely to find fair use. And that's the inverse relationship. Now, why is this happening? And actually, the people who had knowledge of law, it was even a more pronounced effect in terms of knowledge making a difference in terms of their findings. Why might this be so? Well, we posit that what this knowledge effect is showing is that people with knowledge of music or the law have greater sensitivity or understanding of the differences in the legal rules for substantial similarity or fair use. And for the people who have knowledge of music, they have greater sensitivity to the similarities and differences in the musical works. So that's why you would see greater findings of substantial similarity. By the same token, greater findings of fair use, understanding the rule. So that's this inverse relationship. Now, we're planning on doing more experiments, testing the role of musicologists and experts and how they can educate respondents in terms of their understanding of the two musical works. So that's something on the horizon, and if you have further questions about it, here's my email address, and this is a work in progress, so we're happy to take your comments or suggestions on it.
Great.
That these cases are having. Yeah, I don't know why it's not doing. I do IP. Oh. Should I keep talking? Uh-oh. Sing because I might. That's it. Yeah, that's it. Okay. See, don't blame me. I didn't do it. Okay, so in looking at or thinking about the impact that these cases and these analyses have on various constituents within both the musical community and just within our population as a whole, I got involved in this, in the Blurred Lines case, really just, I guess the legal description of it is that I just was ticked off because with the first decision in the Blurred Lines case, meaning when the jury's verdict came out, there was this incredible reaction from lots of, but in particular from the scholarly community. It was this incredible outrage. Am I doing something wrong? Okay, no, it's not me this time. There was this incredible outrage. How could this happen, right? It was as if, one, we always had a perfect system for assessing copyright infringement when it comes to music. And two, never before had this system ever resulted in a verdict that might be questionable, right? And I'm like, wait a second. These are the rules that we have always litigated these cases by. They're in certain segments, for certain communities. You can look at African Americans in the music industry, et cetera, there's a legion of decisions that people would question, and they would say, that doesn't quite seem to be a fair or correct result. And the answer would be, yeah, it's not a perfect system. These are the rules. These are the things that we look at, et cetera, et cetera. So there was never this incredible outrage before. It just struck me as if these are the rules. These are the rules. These are the rules until I lose, right? And that is what got me interested in this. The fact of the matter is that what I think the Blurred Lines case demonstrated, and full disclosure, because of that, myself and two other law professors, we wrote one of the two amicus briefs, because there were only two amicus briefs in support of the gay estate on appeal, right? And I like to say two was all that it was needed, because it came out the way we thought it ought to come out. I think what the Blurred Lines case, and this is one of the things that we argued in our brief, is that what the Blurred Lines decision demonstrate, it illuminated for everybody once and for all that, hey, look, this is not a perfect system, right? What we're doing is we're taking an infringement framework that was conceived for literary works, and we're trying to fit it onto music. And so right there you have an inapt fit. And then, even when we did that as far as music was concerned, at the time that we were doing it, we were thinking about a particular type of music. We were thinking at that time about classical music, which in and of itself is particularly amenable to some of the things that we do when we look for in copyright infringement. For example, it is particularly amenable to written notation, right? And so now we have it twice removed. We're taking something that was created for literary works that is kind of fitting for classical music, and now we're going to try to apply it to other musical formats that are very different from classical music. And, you know, it's like, at what point is the copy of a copy of a copy, is the resolution off? Like, why don't we just stand up and admit that, right? So rather than this great indignation as to the result that happened in Blurred Lines, why don't we use this as an opportunity to make some observations? First, this observation about the tests and the mechanisms that we are using, they are an inexact fit. But while we're on that, let's make some other observations and some other acknowledgments that in addition to the flaws that we see from this inexact fit, some of the other flaws in the system that we had been relying on, you know, for 200 years is that who wins. Another dispositive factor is whether or not you have appropriate resources. Now that includes money, but also do you have resources to hire a musicologist, right? Because if you're doing that first step of the infringement analysis, what's protectable here, right? And if one party says, and I have Dr. So-and-so here, and he says that this is so, da-da-da, and then you go to the other party and they say, and what do you have to say? And he says, yeah, well, I know my music is good. You kind of are at an imbalance, right, in that comparison. And then there's another resource question. For certain types of music formats, do we even have experts, right? right? Or are we importing people who are experts, and this is not a swipe at experts, right? Are we bringing in people who are really, truly experts in terms of certain music forms or music genres, which I don't like to use genre, but that's a whole other thing for me, and then asking them to assess something else, right? And so I think that what the case demonstrated is that, okay, yes, we have some problems here, right? One other problem was that as we are sitting down, let's assume that the fit is not too bad, and let's assume that the expert is a kind of as close as we can get. I also wondered whether or not this also revealed that sometimes some of the assessments that we were making are based upon some extrinsic factors, right? Like whether or not we want to admit it, the race of the litigants. And how that could be relevant, not just in terms of a resource question, is that there is some traditions in our culture of looking at, okay, what nice European classic composers, when they sit down with the quill pen and the music notes, what they do is creative, right? But what you other guys do, that's just emotion and percussion, okay? And that so maybe there are some assessments that are built into what we're doing, right? So if we can agree, or at least for me, I can certainly agree, that, okay, we have an imperfect system, then perhaps instead of being so outraged about the blurred lines, that what we should have done is we should have looked at this as an opportunity to assess what we're doing, to say that the system has some breaks, has some flaws, and why don't we use this as an opportunity to fix it, right? To at least try to fix it. To first and foremost try to come up with assessment mechanisms for music creativity and music copyright and music infringement that is acknowledge that we don't have a great fit and see if we can improve it, right? And then secondly, try to come up with mechanisms that will accommodate a wide range of musical forms and a wide range of musical creativity, right? Because the fact of the matter is that we happen to be blessed or cursed, whichever way you want to look at it, to be in a society in which pretty much almost every musical form is present, right? Because we're the most diverse country on the planet, right? So you don't really want to come up with a music copyright system that says this works really good for one music format and it's kind of crappy for other musical forms, but we could live with that. Why would we? We don't have to, right? So perhaps this is the opportunity to sit down and to look at it from that perspective and to try to reconstruct the system appropriately. I think one last thought that I would add in this shifting of our focus to recognize the limitations of what we're doing and the need to broaden it is to also keep in mind what is the ultimate objective here. The ultimate objective is not to promote one kind of creativity, it's to promote all kinds of musical creativity without regard to what type of musical format you are involved in. The other thing that we want to do is we really also want to get to, well, what's really important here? Yes, what's really important at a kind of a meta-structural level, but also what's important in terms of what happens to music out there in the real world in the actual marketplace. Because something that does strike me about some approaches of breaking it down into these musical components, et cetera, and then stopping there and then, you know, putting up the two slides. I don't mean PowerPoint slides. I mean like two little like microscope slides, like this was, you know, in biology, is that I don't think, if we had two cakes, I bake a cake, you bake a cake, and you accuse me of stealing your recipe, I don't think we would take each cake, put it in a centrifuge, right? Distill the ingredients, and then compare the list and say, ooh, yes, cake, flour, sugar, cinnamon, so ergo they are the same. We would be missing the bloody point, right? At some point, in addition to that analysis, what we got to do is we've got to taste the thing, right? And the fact of the matter is that irrespective of what that centrifugal analysis shows us, we do also have to ask ourselves, when people listen to this, what do they hear? And one of the reasons for me why that is just so critical is an observation and an acknowledgement and a concession I have to make about myself. Years ago, after, I grew up in a particular part of the world, et cetera, and I was not familiar with classical music. So it must have been either my last year in high school or my first year in college, I decided to take a classical music course. And at one point in the course, we were supposed to understand the concept of movements, right? And I'm listening, and dutifully, I still have the 30 greatest classical records. I don't know what they're talking about. It was like a couple of years later, a music that I've always listened to since I was a teenager is jazz. And one night, this is years later, I'm not even thinking about this, I'm listening, and all of a sudden I said, what just happened in that jazz piece? Wait, it happened again. And all of a sudden I realized, holy, that's what they were talking about with movements, right? The sheer truth of it was that there is a certain cultural element, right? That maybe there are some times that I'm not just putting on earmuffs, that I'm not just refusing to acknowledge that this is something like that, right? It's just that I may have insufficient familiarity, right, to be able to detect it. And I know all of this makes all of this so terribly messy. It's sort of like, well, then what do we do? How do we craft a system that's going to give us certainty? But I think that that's, again, one of the curses of diversity. We've got multiple types of music. We have multiple types of talent. The fact that it's going to be harder to go back and sit down from scratch and say, how do we more appropriately apply copyright infringement and acknowledge we have various musical formats? Fine. I just think we need to roll up our sleeves and do that work. And whenever we can't do that work, let's be honest about the fact that, hey, in some instances, the mechanism isn't working. It isn't identifying all aspects of creative contribution. And let's at least acknowledge that, as opposed to be condescending and to say to those musical genres for which the system doesn't work, just putting a derogatory label onto it and saying that, well, what you were doing wasn't creative anyway. That's it for me.
Kevin.
So let me first just say that when I'm talking about cases today, I'm speaking in my personal capacity. The organization I direct, Future Music Coalition, only very rarely takes positions on specific legal disputes. I'm speaking more as somebody who thinks a lot about copyright and tries to connect the concerns of communities that I'm part of. As a practitioner, I'm a record producer and musician for a couple hours a week. To what's happening in policy and to other kinds of diverse communities of creators. And so I'm not sure that I actually have the strongest opinions about these particular cases. I suspect that if I was on the juries, I'd likely have sided with Pharrell, although I agree with much of what you're saying about these resource questions. I would have likely have sided with Katy Perry. For me, the concerns about chilled expression are somewhat muted because of the lack of a legal precedent automatically from jury trials. Of course, we've got to watch those appeals for the potential things that might happen in the future. But zooming out, much of the public conversation about many of these music business topics involving music copyright center on the actions and the concerns of a relatively small subset of high-profile celebrities whose experience is perhaps not representative of the broader population. And so when outliers define narratives, I want to think about who's being left out. Jeff and Sandy both spoke to this a bit on the on the music panel earlier. To get embroiled in a case like this as a company or as an individual, you usually need to be either successful enough to be a target for an infringement suit. If you're not making money, nobody's probably going to bother. Or you need to be successful enough to be able to sue someone, to be able to afford counsel to bring an infringement suit. That is not cheap. Media tends to fixate on these kinds of on these parts of the puzzle because it involves celebrities who sometimes say funny or embarrassing things in deposition. It involves controversy. It involves large dollar amounts. Legal professionals tend to focus on these narrow subsets because they tend to be the kinds of people or companies who could afford to hire counsel. Please understand that's not a jab at the legal profession, but we appreciate lawyers who take on cases on a pro bono or contingency basis, but it's just sort of the practical reality. Academics may focus on these subsets because to the extent that there's legal cases to write about, that's most of what there is to write about. research that captures broader populations of working creators at the ground level and where you spend time actually talking to them and checking against selection bias. That's really hard and time consuming and really hard to fund. Academics who are trying to do that, thank you, I see you. But you see, by the time we get to a policy conversation at the federal level, well, what can policymakers really rely on to guide their understanding of these issues beyond what they're getting through media, through legal discourse, through the academic conversation? And then you have a policy environment where creator groups and small business groups are just so much less muscle than either the big industry players, sure, but also that even is dwarfed by private equity companies and especially large technology firms that have a particular point of view on some of these issues. So I like to think through a situation where a good friend, a mid-career working musician who had a lyric lifted and reused in a song by a multi-platinum artist. This was not subtle, it was the chorus hook. I can't give you specifics, but there would be a potential for a strong, substantial similarity case, and that case will never be heard by a judge or jury because they cannot afford to bring a suit. They don't have access to remedies. I hear stories like this with some frequency. Another friend who found one of their songs was being used in an obvious re-record for an advertisement, no real recourse. It's because they lack wealth and the justice system is not organized around their needs. So for a person like that, a case like Dark Horse may be sort of interesting in the way that watching The Masked Singer is interesting, but it has about as much to do with their day-to-day reality. What would it mean to center the policy conversation on workers like that, on the majority of working creators who are not operating at that mass market scale? I think the CASE Act, which is a piece of legislation that creates an accessible and balanced small claims process, would it be at least be a partial solution, at least to get parties to the table to negotiate an appropriate settlement when that's a possibility. I don't want to turn this into a CASE Act debate. That would be a whole other conference. But as a fundamental policy issue, I want to just emphasize that the access to remedies piece matters a whole lot. And then more alarming to me than the cases themselves is the potential impact on the public discourse and the way that these kinds of celebrity cases can get weaponized in other policy issues and in public discourse. Sometimes by creating kind of a moral panic or sometimes reducing it to something really unimaginative, like, clearly copyright is out of control, and it reinforces this narrative of more copyright versus less copyright, this idea that creators and copyright owners just want copyright to get bigger, and the public interest would be better off if copyright got smaller. And this framing always obscures as much as it reveals, more than it reveals, actually. We need better copyright policy that effectively and equitably rewards creators, enriches communities, serves the public interest, encourages industries to be built on sustainable cultural production rather than extraction of value. Another sort of variant narrative that I worry about is, oh, isn't this funny? Now the big bad companies who argued for an expansionist view of copyright are getting screwed over by this, which is just wrong on multiple levels. That conflates a point of view on unrelated copyright definitional issues like term with questions about what the threshold for similarity should be. But also the large companies are going to be fine. Certainly they'd prefer not to have to deal with this stuff, to be adjudicating these things, but they're going to be fine. More at risk are songwriters and composers, particularly professional songwriters working in these large-scale markets. That population is facing a new kind of precarity resulting in part from format shifts and changes in revenue apportionment. Our research found that professional songwriters who don't record as performing artists themselves, but are just songwriters, are likely to be the most dependent on copyright-related income. These people never sued anybody's grandma over MP3s. They are not responsible for the Supreme Court decision over term length. And so there's the potential that this story, copyright is out of control, calcifies into these writers are greedy, get a real job, which turns into everything's fine. We don't have to listen to these people's concerns about their Spotify rates. Right, so when we allow ourselves to reduce complexity, it can be a really costly error. It can come at the expense of accurate understanding, but also at the expense of empathy and curiosity. I would like to hope that looking seriously at substantial similarity cases could lead us the opposite direction, to say, yeah, creativity is really complicated. There are elements that are original, there are elements that are imitative, and there are elements that are iterative. We can come up with a series of mental shortcuts and analogs to try and reduce the messiness of how creation works and try and shear off some of the complexity and box it into a story that aligns with our preferred view of the world. Policy questions about what we collectively owe to creators and what creators owe to each other, they have legal dimensions, yes, but they also have ethical and moral dimensions that are happening against a backdrop of complicated power relationships. So in an environment of polarization of the discourse, there's not a lot of room to investigate whether that understanding of power relations is accurate and complete and up to date. So I guess what I would say is just let's use these cases as an opportunity to engage with complexity and to deepen our understanding of complexity and look at ways that policy can accommodate complexity.
Okay. So, like Joe, I could ask questions, but I know that the students in particular are interested in having some opportunity to engage with our speakers. So, do we have a student who wants to offer the first question or comment? There's one.
Before the influx of copyright infringement cases in the past couple of decades, a lot of genres in the past, like doo-wop in the 50s and 60s or electronic dance music in the 90s, developed by artists borrowing grooves or combinations of musical elements from one another. Do you think the recent jury verdicts will ultimately prevent new genres from forming because artists are precluded from borrowing combinations of elements that could potentially define a new style?
My immediate reaction is no. I have two responses. One is, I think artists will be more reluctant to admit musical borrowing, which is something that is pervasive, and it goes back to Bach, and musicologists have been studying the practice of musical borrowing, but that admission now, I think, is verboten. It's an invitation to a lawsuit. The reason why I don't think that we're going to see the end of new genres or a new kind of music is that, at least from what I've studied in terms of how popular music is being created today, everybody is trying to create something that is somewhat new, but has some familiarity. There have been studies that have shown humans respond emotionally to music that they're more familiar with. And that gets them back to listen to it again. So I think what producers are trying to do now, and this has been going on for some time, is that they're using kind of a formulaic approach where it's something familiar, but they're trying to do something new. Like Billie Eilish would be a great example. Like people think like her style of music is, different or unique, and people know that she and her brother created their music on an Apple computer in their bedroom. So I think, and somebody referenced this before, democratization of music production. So I think we won't see the end of creativity and the end of new styles of music, et cetera, or whatever. But there is this convergence, as referenced before, that there's a formulaic kind of approach to popular music that creates these similarities.
I would agree with Ed's conclusion, because I think that one of the reasons that there is this sort of like sky is falling fear that the new result is going to be that people aren't going to borrow and exchange anymore is because of the creation of this false narrative that what some of us are saying is that influence, homage, borrowing, all of that is bad. And that's not what, at least I'm saying, okay? What I think on the earlier panel, one of the other panelists, she was explaining that, hey, as an artist, we try to be original, right? If we discover that we have inadvertently copied something, she wasn't saying that, oh, we're like, no, we don't want to do that. because I'm afraid of copyright infringement. I mean, that came later, right? But before these cases, artists were like, well, no, I don't copy. Like, I want to be my own person, right? I think what the issue here is this. It is a spectrum, right? You have, you know, inspiration, influence, homage, borrowing, copying, theft, right? And the problem is that it's a sliding spectrum, right? And what we're trying to do is we're trying to figure out, and what I think artists try to do, no artist, no legitimate artist wants to be here, right? All legitimate artists, first off, they want to be not even on the spectrum. They want to, it came from my head like Zeus, right? But to whatever extent other stuff has an impact, I'm here in this space. And all it is that we're trying to do is to say, let's try to see if we can figure out where the line is going to be, right? And if we can figure out where the line is going to be, all of this stuff here should still happen. All of that stuff is good. That's promoting creativity. All of the stuff that's on this side of the line is bad. Let's acknowledge that it's difficult to find where the line goes. Let's also acknowledge that it's difficult to determine that one line fits every musical spectrum. It may be that, you know, where you place the spectrum in classical music, where you place the line, might be different in terms of where you place it in jazz improvisational music.
Yeah, and I would come to the same conclusion. I'm not really worried about the loss of that interplay or new forms developing. I think that different kinds of communities have different sort of practices about acknowledgement of influence, and I think that there's some kinds of context where people really prize innovation, and this has never been done before, and there are other contexts where wearing your influences on your sleeves and actually just kind of having the coolest influences is something that people try to highlight and, you know, talk about in media interviews and stuff, and they're still working towards the goal of doing something that's uniquely theirs, but have no problem, you know, in part because they're not making any money and not at any risk of a lawsuit, but have no problem talking openly about, yeah, this was influenced by that one record.
So I think actually one thing that Regan talked about was this notion that some copyright in music are thin and some of them are thick. And that's actually a concept that you see in a number of other parts of copyright law. So in music, the thick ones are the ones that are highly original. Gee, I never heard anything like this before. It really was highly creative and kind of stayed away from other things. And then there are things that are kind of pretty common for works of this kind. And so the pretty common for works of this kind, or short parts of those kinds of works, tend to have a thinner copyright, which means that it's more likely that you have to have exact or near exact copying in order to infringe. The thicker ones, you're more willing to sort of say, well, there's too much of what's appealing to the audience about it, so that even if there's this difference and that difference, there is actually this notion that there are different scopes for musical works, and I think that's actually something that we've come to have sort of to articulate more lately than in the past cases for a decade or more before that. So just to kind of supplement, I think it relates to your point, because to the extent that there were little doo-wops, right? The doo-wop part is actually savoir faire, or what the kind of common elements of works of that kind, and so less likely to attract some infringement suits. So we've had at least one question from a student. Any others? I know you had a question or a comment you wanted to make, Alex.
This is for Ms. Smith. I've seen it, you know.
Here comes a microphone.
Oh, thank you. This proposed remedy for
elements of a composition that were not protected by the original deposit copy because they weren't included in it, and you put up the deposit copy of Taurus. And you said there was a remedy where you could deposit a new version of the work as a derivative work that would comprise those elements that were not included in the original. My question is, several lawyers have told me that the problem with that is that the subsequent registration will only cover those elements that were not in the original. So in other words, say in Taurus, in the first 4 measures, it's missing 20 notes, but they're kind of randomly spaced in the deposit copy. Is it true then that you really can't combine the 2 different deposit copies in a lawsuit because they would be considered 2 different works? So it seems like that really is not really a remedy after all, or are these lawyers misunderstanding that?
So someone
Yeah, but
behind
then
you
you
just
would
said
have
sue
to
for
prove-
infringement of both works. You didn't have a mic, so.
Sorry?
Someone behind you just said, why don't you sue for infringement of both
Because
works?
I don't think you can file a lawsuit where you combine 2 different works and say, I mean, it would be considered whether it infringes on one and then infringes on the other. I don't think you can say that it infringed on the 2 collectively because they're considered 2 separate works. That's what I've been told.
So I think that the Copyright Office view, it's not like this is a policy panel, it's not like a policy take, it's just a legal take as to what could come in and be registered. So it was the case that we could only register fixed notation. And then this left things that were unpublished that all of a sudden copyright subsisted in, right? And then we would register it. And so it's also the case that the office, you're not supposed to register 2 copyrights of the same thing, which is going to your point why you would sort of subtract one and have 2 pieces. So derivative may not necessarily be the right phrase for it, but two components of something. And I think that what a court would do is really a question for a court. But I think that whether that is a helpful consideration. I definitely think it's a helpful consideration. I think there's many cases where different versions of works already are registered with the Copyright Office, and courts do manage to sort that out. And it's also I'm not saying we couldn't sit here and spin out interesting hypotheticals, and whether Taurus is one of those interesting hypotheticals or not, I'm not, really opining about. But if what is originally sent to the Copyright Office, and in that case it was four bars, which, are what they are and are described in lots of the briefs, if that's supposed to be the kind of heart of the work, then you could maybe look at that. And if it's these other 20 notes that weren't on there for whatever reason, some of them, honestly very good in terms of people not having this training that is maybe more tilted towards classical notation, you could also register that and see, and that would kind of be up to a court how to evaluate it.
So we have 1 minute left. Blake, did you want to ask a question?
So just wondering about, we've talked today about basically the governance of songwriting, right? What are the rules that govern how people write works? And we've heard of evaluations getting made by songwriters themselves, by basically folks at the record labels doing risk analysis before putting it out. We've heard about the Copyright Office doing some of the work on registration. We have juries doing some of it. We have courts, both trial and appellate, doing some of it. My question is, where is the best institutional home, or maybe what's the right mix of institutional homes for evaluating these questions? Is how we have it allocated now the right mix, or if you could change it somehow, what would that be?
Oh, that's a 1 minute question for sure.
Well, I I think that it's hard to know exactly where the baseline is because you do have these different bodies talking about things. This will just kill the 1 minute, but one of the cases that didn't come up that I thought was really interesting was the Pound Cake case for Drake. And that is interesting because the sound recording was licensed and the musical work was not, and they won on fair use. But when you actually kind of get into why is it fair use, some of it is kind of based on how it might be used in hip hop specifically. But one of the lyrics is like about the A&R man. And if you don't like the A&R man telling you how to make your sound, I think one article that was interesting that got a lot of like chatter in DC is like the insurance company telling you how to write your song, and that might be a sign. If that's really, really what's going on, that might be a little too far. So.
And with that, please join me in thanking our panelists. I think we have another 15-minute break and then a final panel, which will be dynamite.